Welcome to the first video of McCase's channel. And since this is our first video, I'll take some time to explain what we plan to do with this channel. In this channel, what we'll do is that we'll do basically case digest. We will select cases from primarily due to our jurisdictional situation. Primarily, we will be picking cases from the UK and also from Malaysia. Now, case digest or case study is something common that students or readers of law will have to do. But the general public, naturally understandable, will not be, or at least are not expected to be able to fully glean the impact of a particular case on the development of the legal system in a particular country, in a particular common law country, like, for example, in the UK and in Malaysia. So what we plan to do here is that we will do a case digest or case study that avoids overly technical discussion like we would do in, for example, in a classroom or in a tutorial or in a lecture. But what we will avoid at the same time is to avoid dumbing down the salient points or the points that the particular case was trying to make to the level where it is completely taken out of context, or it's completely pointless talking about it in such simplistic manner. So we try to find a balance between the two so that our audience, hopefully students and layperson, and even lawyer doing preliminary research can utilize our video to their advantage. All right. So without further ado, our first video today is Peguam, Negara, Malaysia and Malaysiakini.com Sdn Bhd. Basically, this is the Malaysiakini contempt of court case. Now, at the time of recording, only the summary judgment or summary majority judgment is out, and the minority full judgment has been published. The majority full judgment is not available as of yet. So we will have to evaluate based on the summary, the press summary provided by the federal court. All right, let's talk about the facts of this case. The facts of this case is actually quite simple. It all started on the 9th of June 2020, which is about 6 months or seven months plus ago. Malaysiakini uploaded a news piece on their news portal website. All right, and their news portal website, at the bottom of the news piece itself, there is a section that allows readers to leave their comments and whatnot. I can show you this, in fact. So, for example, this is a Malaysiakini website, and there's a piece of news here, and well, it's behind a paywall, and I'm not subscribed to this. But at the bottom, there is a comment section. As you can see here, there's a comment section. Well, the issue with this case is that several comments made by readers of Malaysiakini on the 9th of June that was uploaded onto its news portal was deemed to be contemptuous of the court. All right. So what I've done is I copied these are the infringing comments that was reproduced in the judgment of the majority. You can have a look in the published judgment itself. So these people are not Malaysiakini. All right. They are just readers that leave their comments on Malaysiakini news portal on a particular piece of news lah. And the comments were left there for a few days. And on the 12th of June, the police informed Malaysiakini that they are investigating Malaysiakini for the few comments that was uploaded. I do not know whether the police informed them on which section they are investigating on. I mean, we are not privy to information as to whether Malaysiakini was informed of the grounds of investigation and whatnot. But nonetheless, the moment the police informed Malaysiakini, they took down the comments. Again, we don't know whether the whole comment section was deleted or locked, or they just took down the offending comments. We're not sure. But they took down, according to the judgment, the offending comments within 12 minutes of being informed by the police. Nonetheless, 3 days later, the Attorney General still initiated a contempt of court proceedings against Malaysiakini, the company, and also its chief editor. Okay, so that's the facts of the case. Very straightforward. All right, let's look at the point of law that is in contention here. The act that was used, the particular section that was used is Section 114A of the Evidence Act 1950. Now, of course, Section 114A is an amendment that was made, if I'm not mistaken, sometime in 2012. And during that time, there was a lot of media uproar over the proposal at that time to make this particular amendment to the Evidence Act, and a lot of media companies and civil society groups were protesting against this amendment. And if I'm not mistaken, Malaysiakini was one of those parties that participated in this protest. Nonetheless, the section amendment was passed and it came into effect subsequently. Now, what is the issue here? I mean, the particular section itself is very wide. It is quite, it is drafted in such a way that it grants the executive, in this case the police or the Attorney General, a lot of power to prosecute people who may or may not publish things online, particularly online, that are offending. Okay? How it works here is that Section 114A creates this thing called a presumption of publication. Now, of course, if you publish something online in your own name, so you write something that is contemptuous or something that is defamatory against another person, and you publish it online, of course, naturally, if that person were to go after you for defamation, or the police or the Attorney General were to go after you for contempt of court, then you will be liable. Of course, there's no question about that. That's very straightforward. The issue here that we are concerned in this case is regarding non-authors, this particular issue with non-authors, because Section 114A creates this presumption of publication even for non-authors. So, to explain it in an analogy, imagine if I own a website, okay? And in that website, I talk about matters that let's say concerns the public, okay, and I allow readers of my website or my blog to participate in discussion on the website itself. So again, like there is a comment section or there's a thread for comments, and if there are people who write their comment on my website, which of course I did not author those comments, but nonetheless I facilitate the website. That means the website belongs to me. I maintain it, I manage it, and I curate it. One of the keyword here is the ability to edit and whatnot. So let's say I'm the curator of this website. Then this Section 114A would presume that I am a publisher of those offending comments, even though I am not the person who wrote them. I am just the person who maintains the website where these people who wrote the comments upload their comments. So the keyword here is facilitates. Yeah. So if a non-author facilitates the publication, then it is presumed that the non-author is the publisher of those comments. Now, of course, this presumption can be rebutted, and in this case, we'll see how this was applied and under what circumstances, what kind of standard that the court is expecting of a person to rebut this presumption. Okay, so now to summarize, the three questions that the court has to answer in relation to this case is, of course, number one, whether the statements are contemptuous. Now, of course, if the statements are not contemptuous in nature, then the entire case would collapse right there itself, and there's no reason to answer 2 or 3. But if they are contemptuous, the second question the court has to answer is, does non-author publication in Section 114A require either this intent element, that means this intention to publish, or this knowledge that such publication has happened? So, for example, let's say I have a Facebook account and I write a post that is public on my Facebook, and a lot of my friends and strangers commented on my post. The question then becomes, if I do not delete their post, if that post is contemptuous, naturally Section 114A creates this presumption that I am the publisher of those comments. But what if I don't know? Let's say the post went viral. Okay, the post went viral. Thousands of comments are pouring in by the day. And as a single individual owner of a particular Facebook account, there is no way I can curate a situation like this, meaning that I will not be able to keep myself updated of all the comments that are coming in. Naturally, you have comments that are mild, but at the same time, chances are you're going to get comments that are quite hostile or potentially illegal or offending. All right. So the question then becomes, if I don't know that such comment was happening until I was informed, all right, then can you still argue that in my lack of knowledge or my lack of intention to publish them, Section 114A will still consider me to have fallen under the presumption of this publication? All right. So that was the second question. Does Section 114A requires non-author publication to include the requirement of this knowing or this intention to publish? And of course, finally, is Malaysiakini successful in rebutting the presumption of Section 114A? If they fail, then of course they are liable. We know the result. Malaysiakini was fined 500,000 ringgit, and they were found guilty of contempt of court. So we know the answer for this. So we are concerned more about the second question here. All right. So how do you apply Section 114A, and what does it entail for freedom of speech and the kind of duty that a party has when they maintain an online presence? All right. So let's look at the decision based on the three questions that was mentioned prior to this. Are the statements contemptuous? Now, there's no question here. Actually, it's very simple. Every party, whether the majority judgment or the minority judgment, all of them, even Malaysiakini, agree that these statements are contemptuous. So there was no legal or factual questions involved in this situation. But it's where the second question is where the parties differ significantly. All right. Does non-author publication requires the element of either knowledge or intention? Again, all party agrees that knowledge or intention is required. Well, specifically knowledge. This is where they concentrated their judgment on. Knowledge is definitely a requirement. The question then becomes: is knowledge actual, or can knowledge be constructive? Now, this is very legal terminologies, but essentially what they mean is actual knowledge means the person, in this case, Malaysiakini, actually knows about the publication of these comments. So ultimately, this becomes a factual issue. Do you actually know? If you don't know, then you don't have actual knowledge. All right. But if you know, then you have actual knowledge. Now, of course, we know reality cannot be that simple. What if you ought to know? What if you should have known? Or what if you are so reckless that things that you would have known, you didn't know, but still, I hold you that you should have, in this circumstance, known about this publication or these comments and whatnot. All right, so that is what we call constructive or inferred knowledge. That means, in short, you ought to have known. All right, the majority of the quorum, 6 out of the panel of 7 judges, held that inferred knowledge is possible, and knowledge can be inferred or constructed from surrounding facts and circumstances. Okay. What is interesting is that they gave the evaluation of the fact that they found that Malaysiakini has constructive knowledge because, among other things, Malaysiakini has a full active and passive control over the publication. So you have publishers and whatnot that are in full control over the website. They can delete things and they can add things, and they are in control over what is published on their website. All right. But they also have passive control in the sense that they have this automated system. I can't remember what is it called. It's a program that they were using in Malaysiakini website, that they automatically detect foul language and inappropriate languages, which the system will automatically filter out. If you attempt to write something, or write a comment or publish a comment on their website which contains bad words and things like that, it will automatically filter these things out. And the judges were of the opinion that since you already have the capability of filtering certain inappropriate posts, then the system, you cannot argue that the system cannot filter out other posts that are potentially, for example, defamatory or contemptuous. I know it's a little bit different. I mean, it sounds like it's a similar thing, because identifying foul words is one thing, but identifying concepts from a chain of words, it requires exponentially more powerful programming that we may have, but it may not be that as widely available. But at the same time, it may not even be 100% foolproof. So there are a lot of issues surrounding this automated filter situation. But nonetheless, the majority is of the opinion that since you have actual control, and also you have passive control, like for example, all this word filtration programming, you are found to have a duty to exercise this such control over the comments that was published on your website. Another example that the court gave was also an arithmetical calculation, and I find this quite problematic because it says that Malaysiakini has 25 staff, half of which are active editors of the websites, and they manage around 2,000 comments average a day. Now, I do not know how they come up with this figure, and I do not know whether this is still representative of Malaysiakini readership situation now. But let's just presume that it is. And the court is of the opinion that based on such circumstance, failure to know, there is no excuse, is no defense. All right. The problem with such an approach when it comes to testing or setting up a test in law is that you are creating an arithmetical delineation that doesn't really exist in reality. For example, what if Malaysiakini has 25 staff, but they suddenly go viral and they are managing 20,000 or 30,000 comments a day? Then can you say that under such circumstances, it is a good enough defense that the staff doesn't know because, they have more comments than they can go through? What if we have, say, 250 staff, but it's a worldwide global company managing not just 20,000, not even 200,000, we're talking about millions of posts a day? Then under such circumstances, can the particular party claim that they have no knowledge because it's impossible for them to filter through actively, in actual person filter, every single comments that was uploaded into their website? So this is basically the main contention of the majority. All right. The minority, however, held that knowledge ought to be actual and cannot be inferred. And the judge specifically mentioned that this is important because we're dealing with a we're dealing with criminal contempt of court here, meaning that we have to be mindful of the burden of proof in criminal cases. It's not enough to say that I think there is a good probability that you are guilty of a criminal offense. No, I must be so sure that there is no doubt left that is reasonable that you have committed a criminal offense. And that is a standard of criminal offenses in terms of burden of proof. That is fundamental to all criminal cases. And the court is of the opinion that since we're talking about criminal cases and not civil cases here, inferring knowledge is fundamentally dangerous. So she said that inferred knowledge should not be used on non-author publication situation. Now, if you are an author and you publish a particular offending remark, then of course you can't say that you have no knowledge. The issue is when you are using section 114A on people who are non-author of online publication. The court is of the opinion that, the minority is of the opinion that actual knowledge is a little bit too dangerous because that potentially makes everyone a publisher. That puts everyone in a precarious situation whenever somebody posts something on their social media or their online platform. Whatever it is, as long as you have an online personality, the moment somebody publishes something even if it's just like for 3 seconds or 5 seconds or 1 hour, before you saw it, before you know it, and you take it down, that period of time is enough to land you in trouble with the law, if you were to infer knowledge. Yeah, so that was the main point of the minority. The minority judgment also held that there is an alternative solution, which is called the flag and take down approach, meaning that you can't expect everyone to know what other people post on your online presence or identity or profile all the time. But the moment you are informed, either by authority or by some automated detection rubrics or whatever, the flagging, all right, and you take it down, then you should not be considered to have published those particular offending remarks or comments. So, right, and the minority is of the opinion that this approach is more appropriate, especially so in criminal cases. And inferred knowledge is dangerous, as any delay in taking down publication can be considered publication itself, which is what I've mentioned just now. So majority held the Malaysiakini based on these points here. Yeah, they have control, and it is not overwhelming. All right, it is not an overwhelming situation, and they should have or could have known about those offending remarks, and they fail to take them down. So Malaysiakini failed to rebut those presumption of publication as provided by Section 114A. All right, let's talk about some observations that we can derive from the majority judgment in this case. The first observation here is that I find that the standards that the court set and the duty of care that the court expect based on the judgment is way too high. Now, I'm not trying to say that there should not be a limit on free speech. There is always a limit on free speech. The key word here is, where do we find the balance? If you were to say something that is defamatory, then you are, of course, naturally liable for the consequences that flow, or legal consequences that flow from your action. The issue that we have here is not that it's set a standard that is too high in relation to freedom of speech, but rather it sets a standard that is way too high for people who maintain online platforms and forums and profile to check on the potential danger that was brought on by readers who comment on their websites or their profiles or whatever, that to the extent that now it is safer to automatically, or rather to censor free speech as a default mode, meaning that you rather have people post comments and to have someone physically check every single comment before allowing it to be published, or have a system that is so discriminatory in nature that anything that smells even potentially dangerous is automatically censored from publication. So it's these standards that we are now faced with, that I find that it forms a form of automatic gag on free speech. That means that it seems to suggest that the presumption is there is no free speech until it is ensured that whatever speech is about to be published is not defamatory or not in contempt of court or whatever. So in that sense, one of the biggest emphasis that the court was talking about in the case is this automated filter that Malaysiakini was using. The problem with automated filters are, if you're filtering words, of course it may work or it can work. But if you're filtering concepts, now this is a different level of filtration we are talking about. You need artificial intelligence that are not only human level, but extremely competent level, that maybe we do not have the technology yet. But even if we do have the technology, it will still not be 100% foolproof, meaning that a lot of comments will fall through the filtration system. And if that was the case, then really online managers of online profiles and websites and discussion forum will never be able to be sure that they have discharged their duty adequately if we were to base this interpretation on such on this case, the decision of this case. All right. And second thing is that, I mean, in relation to Malaysiakini, we're talking about a news portal here or a news channel, and they are publishing 10, 20, 30 news pieces every single day. And they've been doing this for years. And the problem that we have here is that if you were to allow a comment beneath if you were to allow a comment section beneath your news piece, then how do you at all times ensure that every single news piece is free from contemptuous statements that was made by some random readers that are tracing back years and years of old news that you have? And that seems to suggest a duty of care standard that is so high that the only way to fulfill this requirement is to either switch off your comments when you, after a certain X amount of time, meaning that, for example, if I were to publish a news piece now on Malaysiakini and I'm the editor, I publish a news piece now on Malaysiakini website, I will staff maybe 2 or 3 editors to curate the comments all the time, because that's the standard that you are expecting now. And because I can't permanently staff them to this particular news piece, so I will switch off the comment section the moment I need them to pay attention to another news piece. So maybe I will keep the comment section open for a day or 2, and that's it. I have to cut it off. And that comes back to this thing. It seems to suggest that there is an automatic gag on free speech and freedom of speech, which is I find these standards unreasonably high. Okay. And the second issue that I have with this decision is that the court attempted to distinguish the current facts from the facts of Re Prashant Bhushan. Re Prashant Bhushan is an Indian case concerning a lawyer who made a couple of tweets that are contemptuous of the court in India. In that case, of course, Prashant Bhushan was found guilty of contempt of court for tweeting those tweets that are contemptuous, but Twitter is exonerated of that responsibility. That means, of course, you can't assign fault to Twitter, but you have to go after Prashant Bhushan himself. The situation is distinguished from this case by the courts, by the majority judgment, by the very fact that, according to the judges, Twitter is not in control of what Twitter accounts are posting. Or at least that's my interpretation, because I find it really odd that they would say that, because it's either a complete misunderstanding of how Twitter functions, or I may have misunderstood something severely going on here. So basically what they're saying here is that because Twitter is not in control of what individuals like Prashant is posting on their feed, then you can't hold Twitter responsible for the actions of this individual. But then again, wouldn't it be safe to say that Malaysiakini shouldn't be held responsible for actions or speeches that are contemptuous in this case, that are not made by Malaysiakini, because Malaysiakini is not in full control of what you are saying, what individual readers are saying. These individual readers, if they want to say something and they upload that something which is contemptuous, is not within the control of Malaysiakini. Now, of course, we have gone through this just now, and the court have said that, well, Malaysiakini is in full control. And, well, they're not entirely wrong. It is true, Malaysiakini can be in control. It's just a little bit unreasonable to expect Malaysiakini to be in control all the time for every single news piece that goes back years. But let's just presume, okay, fine, because Malaysiakini is in control, hence they should be responsible. Then isn't it the same as saying that because Twitter can delete tweets that are against its user policy, then Twitter should be responsible? Then how are you distinguishing from Re Prashant? Now, Twitter has been known to have censored some posts. In fact, Twitter recently has completely removed a user, which is Donald Trump, that has consistently been breaching its user policy. So it would be very wrong to say that Twitter is not in control, because Twitter is a platform provider that has an ability to delete your tweet, censor your tweet, or completely even delete or lock your user account altogether. So I think that distinguish there is nothing that distinguishes Sri Prashant Bhushan from Malaysiakini situation other than scale. So it's a matter of scale and degree, not a fundamental substantive differences that we are talking about here. So I find that distinguishment a little bit difficult to justify. All right, the third observation that I have regarding this case is that the court decided to end their judgment by citing Lord Denning in Ex parte Blackburn number 2, and seemingly completely out of context. And they've taken what Lord Denning said, which of course applies in this situation, but they've come to completely opposite decision from what Lord Denning was saying. What happened in Blackburn number 2 is that there was a guy who published an article criticizing, it was a printed publication, so criticizing the Court of Appeal in the UK's decision regarding certain cases. And it was found out that this criticism contained some error in analysis. He was erroneous in his evaluation. He talked about how the court may have erred in law, which the court in Ex parte Blackburn number 2 decided that there was no error in law. The criticism was unfounded on it's unfounded and it contains erroneous analysis. Lord Denning was talking about how the court should be very careful. Judges should be very careful when dealing with cases like this, because you are asking a judge to adjudicate, or you're asking the court to adjudicate on issues that concerns the court itself. It's literally what we call in law nemo iudex in causa sua, not to make a person, a man, a judge of his own cause. So basically what it means here is that, if you as a judge are personally involved in a particular case that you are now adjudicating, then you should not be a judge you should not be in a capacity to adjudicate something which you are personally involved in. Lord Denning, in the case of Ex parte Blackburn number 2, talked about how the judiciary are not capable of physically answering criticisms like how politicians or the executive or members of parliament can make public statements that answer criticism against their action. The only way the judiciary can answer criticism against their action is through their own decision. And as such, Lord Denning is of the opinion that, number one, the courts ought to be very careful when they're dealing with contempt of court cases, because nemo iudex. And number two, Lord Denning was saying that, the court's reputation is not so fragile. The courts do not shy away from criticism, and whatever criticism you level against a judge, the courts do not affect the court's ability in performing their fundamental duties. And of course, number three, Lord Denning is of the opinion that just because statements contain mistakes or statements are very critical, are very passionately critical of the judiciary, and made on top of that misinformation or mistakes or error of judgment or error of evaluation or analysis, does not automatically make that particular piece of statement contemptuous. Because Lord Denning is of the opinion that you need to balance this error against one of the very fundamental right of a person in the UK, which is the right to free speech. That being said, Malaysians also, subject to certain limitations, also have a constitutional guaranteed right to free speech. So that if a person's speech, in exercising his free speech, and in saying what he wants to say, he made an error, and if we were to follow Lord Denning's judgment or his line of reasoning, then an error or even a passionate criticism itself, even if it contains error, ought not to be considered contempt of court. All right, and that's what Lord Denning said in Ex parte Blackburn number 2. And the judges in Malaysiakini contempt of court case choosing to cite part of what Lord Denning said, but coming to the complete opposite in their decision, stating that yes, the judiciary, due to the nature of their function, are unable to physically answer or personally answer to criticism. As such, there should be some level of of decorum that the public needs to treat the judiciary with. And if your statement contains misinformation, it's wrong and malicious, then that should be a contempt, and this should be considered a contempt of court, which is the complete opposite of what Lord Canning said in Ex parte Blackburn number 2. I find this baffling. I do not know why. I'm still waiting for the full judgment to see, is there some nuanced argument going on here. But seriously, based on my understanding of Blackburn number 2 and based on the actions of the judiciary in the Malaysiakini case, in not only finding Malaysiakini in contempt, which is now in conflict with Ex parte Blackburn number 2, but on top of that, to up the penalty from what the Attorney General asked, which is 200,000 ringgit, to 500,000 ringgit, it's baffling. What message the judiciary is sending out? To me, I find that very baffling. But of course, I'm still waiting for the final judgment, the full judgment to be published, so that I can see whether there are nuanced argument that may not have been reflected in the summary judgment itself. So yes, that is my observations of this case. I personally find that this is not a very good precedent that we're setting in relation to Section 114A of the Evidence Act 1950. It is dangerous, and in the future, of course, this is now binding on lower courts. But I would prefer, or I hope, that future courts, future cases, judges will find ways to distinguish from this case. Thank you for watching this episode of our very first episode of My Cases. If you would like to show us some support, if you like our content, you can click the like button, and you can also click the subscribe button to support us. You can also comment and let us know how we can improve on this, and tell us what would you like to see, what cases you want us to talk about. Thank you very much.